Readings from the book of Reddit. Let us pray. It's been said that bankruptcy is a pig fest. The lawyers gouge and gut so that only morsels are left. Second reading. The UCC sold out innocent retail investors. They're as bad as Alex Mashinsky. 3, my personal favorite. Those goddamn mother effers from the UCC credit group, the scumbag lawyers we all see on Zoom court from the law firm of Brown Rudnick, yes, Robert Stark, and his sidekick, Tonto effing boy wonder Ken. Those of us in the bankruptcy space were initially really interested in Reddit. Then we quickly learned not to be really interested in Reddit. But maybe they have a point. Crypto did its first foray in bankruptcy. Congratulations. And it wasn't very good. Voyager, Celsius, BlockFi, Genesis, Prime Trust, FTX, among many others, none of them reorganized. None of them were sold as going concerns. Few of them, or I guess none of them except for the mining business from Celsius, actually emerged as viable business enterprises. These were liquidations, and shockingly expensive liquidations. And meanwhile, for really long periods of time, investors were separated from their crypto. Or worse, they were told that what was their crypto actually wasn't their crypto after all. It was the company's crypto, and they're left scraping for the bottom as general unsecured claimants. It seemed as though bankruptcy only incrementalized and exacerbated the problem. Didn't help much. So Steve gave us 40 minutes, although I think he spoke for most of our 40 minutes, about how we're supposed to learn from all of this, which is super, super, super easy. But fortunately, I have this panel, and it's a really, really good one. We start with Professor and Assistant Dean of Vanderbilt Law School, my good friend Yesha Yadav, world-renowned scholar on all things markets, but in particular, a scholar on crypto markets, which is a very interesting academic subject. So much so that when the Senate was trying to figure out what the hell happened here, they asked Yesha to come and appear before Congress and explain it to them. She's also my very good friend and co-author on an article that just came out, or soon to be coming out, on this topic.
It's out.
It's out? Mm-hmm. Okay. And boy, we learn a lot from just spending a couple of minutes with Yesha telling us what to do. Next to Yesha is my good friend, one of my very oldest friend, David Brill. He's a managing director at FTI Consultants. Maybe some of you know David. He is one of the longest and, in my opinion, loudest advocates for your industry. And he knows what he was talking about. He was the assistant general counsel at Voyager. He was, prior to that, the general counsel at Genesis. Gemini, excuse me, I keep making that mistake. He was always in the room. And because he was always in the room, he kind of knows what happens next. And from there, at FTI, he's advising company after company about what is likely to happen next. Next is the great and powerful Wizard of Oz himself, Mr. Meghji. Here's how I describe Mo. If you're a billionaire or a Wall Street titan, or you're the C-suite, and you have a problem, you say to your vice presidents all around you, don't give me the answer, you better call Mo. And he's on that speed dial.
Little overstated, but that's fine, thank you.
Well, okay, we'll let the data do the talking. Advisor to Genesis, advisor to Prime Trust, advisor to the official creditors committees in Celsius and BlockFi. The man who today is overseeing their case resolutions. So maybe it's not so overstated after all. And then next to him is the Tonto effing boy wonder, Ken Aulet. Not only is he my partner, he is, in all sincerity, the brains behind everything that's crypto bankruptcy at Brown Rudnick, and that's been quite a bit of work that he's been doing. He is the leader of the Fair Deal Group in Genesis. He co-led with me the BlockFi engagement, and he and Mo together just recently cut that big deal with FTX, which got all of BlockFi claims paid in full from FTX. So he knows an awful lot what he's talking about as well. That's my introduction to you of a panel that will answer all of your questions in now 30 minutes about bankruptcy and crypto. But let's do this in 3 topics. We'll do it in sort of stages. The first is, how are we supposed to think about our 2022-2023 experience? Your industry's first foray in Chapter 11. From there, we're going to ask, did we learn anything from this? And then in particular, what did you folks learn for purposes of future deal making? How should you think about this experience? And what things should you do that might be differently, that might help you in the future? Okay? Yesha, this is the easiest question we're going to have today. I pose it to you. How's bankruptcy supposed to work in this particular industry? And you got like 2 minutes.
I wish that were an easier question, Bob. And thank you so much, first of all, to Brown Rudnick. Thanks so much to Steve for bringing us all together today. And thanks so much for starting this panel by discussing the John Wick of the legal system, which is, of course, bankruptcy. And that kind of epitomizes what bankruptcy is supposed to do, which is figure out what's good and what's bad, right? To take a sinking Titanic and to figure out that you need to save Rose and kill Jack. You know, that is the basic purpose, to take something that is big and complicated, to take a pause, to figure out what the hell is going on, and then to, you know, take a stab at finding that piece of the sinking ship that has some ongoing value, and then bringing it back to life somehow. Right? That is the job that bankruptcy ideally is supposed to do. And we're going to spend a lot of time, you know, kind of being on the bankruptcy system through this panel today in respect to crypto. But it's actually an amazing system, Bob. As I think all of us in this room know, we are the envy of the world when it comes to Chapter 11. We have an incredible bankruptcy judge, you know, judicial system. We have an incredible set of practitioners and advisors. We have a really good history in bringing companies back. But it's just not worked in the case of crypto. There's a couple of things that bankruptcy needs in order to work really well, which is, one, it needs the ability to be quiet, to stop the drama, to put a pause, to make it work. In addition, it needs regulators to be on board, right? So when you have regulated industries like the finance industry, telecoms, Enron, even the airlines, regulators are working alongside the bankruptcy system to make this work. In the case of crypto, we did not have time and we did not have the regulators on board. And we had a lot of people, and we had Reddit and we had Twitter. And unsurprisingly, with all of this mess, all of this drama, the bankruptcy system was set up to fail from the start. So even as we talk about what we're going to talk about today, we have a great system. It did what it was supposed to do, but it just didn't have the tools to do it well.
Mo, first tool, you got to finance the thing. And then you got to find a solution for the thing. Can you build off of what Yesha's talking about?
So I will, you know, I'm not an apologist for the restructuring industry in every way, but in some ways. I think the issue of cost is, in Chapter 11 cases, is something I fully acknowledge that's an issue. But you step back and you look at where this industry was. The crypto industry, the crypto finance industry, and these exchanges were at the earliest possible stage of development when this train wreck happened, which was driven by fraud, by several influential people that created this. So when you take an industry that is in its infancy, number one, combined with, I 100% agree with you, the regulators failed this. There should have been much better regulations. If you look at financial institutions, there's a system. If you look at any bank failure, there were 3 bank failures last year, Signature Bank, SVB, a couple others. There was a clear process for that. Even in the financial crisis, when when Lehman failed, there was a process. That process has been perfected since the financial crisis. But I think what the irony of this is that the crypto industry got built very fast off of a lot of, from my standpoint, social media hype by folks ultimately who were customers, participants that were very cynical of the regulatory system, the Fed, all of that, but ironically trusted some nefarious individuals that created this. So let me make one more point, because I could go on for a while, but the last point is it came into bankruptcy court in sort of a very, very accidental fashion. The bankruptcy industry, if you look at companies or industries that have, so if you take the retail industry, which has had hundreds of bankruptcies. The first time a retail bankruptcy happened, it was terrible. It was mismanaged. But over a period of time, there is a process. There's a playbook. This playbook for crypto just did not exist. So folks like Ken, Robert, myself, and others who do restructuring needed to figure out what this beast of a business was. And judges needed to figure that out. And that's been the process.
Judges who are old are not up to date. But David, let's do this, because I want to make sure that we have our categories down, because we bankruptcy lawyers make lots of mistakes, and so we would like to know from people who are smarter than we are. When we talk about the crypto bankruptcies, it seems like a broad brush, because there's lots of subcategories. And so what happens in FTX may have a halo effect in core scientific, and that's not necessarily fair, right?
Yeah. So first, I just want to say my views are mine of my own and not of FTI or my former employers. So I want to say a little bit of the quiet part out loud. Part of what you saw with the crypto bankruptcies was a replay of the financial services bankruptcies of 2007, 2008, with a different flavor. And as my fellow guests here have said, yes, there hasn't been robust regulation. I don't think there's been robust regulation because I don't think our regulators have really made the effort to create robust regulation. But taking a step beyond that, it's really important to look at the different bankruptcies that occurred. And I'm going to make my arbitrary categories. You can agree with them or not. But I think on the sort of more, we'll say, mischievous side, you have FTX and Celsius. You know, entities where you really didn't know what they held at the time of bankruptcy. You didn't know where they existed, what they held. You know, Alex made a lot of proclamations about what they had, what they didn't have. I think once people went under the books, you saw what they didn't have. And then you had several, like my old company, Voyager, and Core Scientific, which had existing running businesses and that had just real business functionality issues, we'll call them, or risk management issues, but not of a nefarious nature. So one of the challenges as you go into one of these bankruptcies is, especially for people outside of the business, is you look at them and say, are these good actors? Are these not good actors? Is what you're being told they have accurate, or is it inaccurate? So I think whereas in other bankruptcies, you probably had a good sense of what assets existed and didn't exist, and a pretty good sense on what the value of those assets were. In these crypto bankruptcies, you really didn't. And because the crypto markets are volatile, although much less volatile now than they were, the amount that these companies had, you know, varied significantly. And I'm going to put FTX to the side for a minute because I think that was the most complicated. But when you looked at some of these businesses, I think there are ways very quickly to decide, would there be someone interested in buying them or not? You know, is the technology worth something? Are the client lists worth something, or are they not? In the case of Core, you had materials, you had machines, you had Bitcoin mining machines, you had materials that could be valued, and that could be rolled up into another company in the mining space. And I think that's a fair way of describing what HUD 8 did with Core Scientific.
Right.
In the case of Voyager, you really did have a working platform, a really user-friendly working platform, and you had over, you know, millions of clients. But besides that, you didn't have an ongoing business, and you had one that was underwater. So if you look at that one, you know, that should have been a very quick, either someone buys the client list, somebody buys the technology, or not. And then in the other two, I think it's fair to say that because, you know, their books were opaque, and I use that word lightly, but people really didn't know what they were buying, and they needed time to figure out what they were buying. So as you kind of look at this waterfall of different companies, and we're going to go into this further, I think there were different results that could have happened for these companies because of where they sat. And I think, look at Core, I think it got to the right place. If you look at Voyager, my view is that it should have been liquidated very quickly after a sale didn't occur.
Well, let's put a pin in this.
Okay.
Okay, let's put a pin in this because I want to come back to it because I think you're right. We learned a lot in 2007, 2008, and maybe we forgot some of that when we got this time, or maybe we didn't. And I want to unpack that a little bit more. And I know, Mo, you have a lot of experience on this. But I lied before. That won't be the first time today I lie. The hardest question wasn't Yesha's, it's for Ken. Okay? Explain this procedure that the Reddit community hates you and me so much about, where we kept them away from their value for so long and just dished the expense on top of the expense. What did we do wrong?
So all of these bankruptcies were what are called Chapter 11 bankruptcies, which are to reorganize a company. The idea being that for most companies, it's worth more alive than dead. You have a factory, you shove, $5,000 worth of metal, $10,000 worth of labor in, and you get a $20,000 car. The company is worth more alive than dead, and so everybody has an incentive to keep the company alive. Just who gets the company at the end. As everybody's been talking about, there's a difference between that and financial bankruptcies. A lot of these companies were financial firms where all they really do is borrow and lend out money. And Chapter 11 doesn't work for those firms. In fact, it's generally banned for financial firms to file Chapter 11. Lehman Brothers, banks, all of these companies have to go through a liquidation. They get the week before they collapse to sell themselves. If they don't do that, then they can sell themselves over a weekend. And if not, they're immediately liquidated. The bankruptcy essentially begins with the CEO being thrown into the trunk of a limo and driven off screaming, and an independent trustee appointed. But, for example, BlockFi, even though it is in all respects like a financial firm, just dealing with crypto instead of dollars, it is eligible for Chapter 11 and not Chapter 7. So you have management who got the company into the problem still running the show, and as a counterweight, you appoint a creditors committee to represent the creditors. And that makes sense if you're running a factory. Even if the people running the factory didn't do the best job, they know where all the buttons are, and you need to keep the factory running. But if you are not going to keep the business running in a financial firm, if it's been dead for a week, it's dead. There's no bringing it back because it's lost all of the confidence of the market.
Oh, wait, and I don't mean to interrupt you, but Mashinsky was not thrown into the boot of the car on the first day. It took, what, 4 months?
Exactly, because
It took
all of these companies...
2 months.
Okay, 2 months. But there was a lot of momentum in the case in the wrong direction while he was still kind of running his narrative.
Right.
And we had to make, and I'll just jump in, we were super involved in this. There needed to be very careful consideration about whether you go and force a Chapter 11 trustee, you convert the case, and we had to have very strong, blunt discussions with Celsius's counsel and negotiations to figure out a way to get him out consensually. But that took time.
And the problem is that all of these companies filed Chapter 11, and management has nothing really to do but to protect themselves from lawsuits for getting into themselves.
Okay, put a pin in this. It's not the creditors committee's lawyer's fault. We're here to save the day. It's the damn debtors, and that's the answer to all questions in bankruptcy. Okay, did I cut you off too early?
No, but...
I did.
Yes.
Sorry.
And so all of this conflict comes because management still runs the company, and the creditors don't actually get nearly as much of a say as they would like. And so you have conflict there where normally the playbook for financial bankruptcy is everybody's out, appoint a single independent trustee. That may not be popular with creditors, but it is cheaper and it avoids as much conflict.
Let's see. I'm just looking at the time. Let's seek over to what we in the bankruptcy community, before we go to what all of you in the commercial community, what did we learn from all of this? And Yesha, you've written a lot about the failure of regulatory oversight and how when you seek into bankruptcy, bankruptcy can't kind of play quasi-regulator and kind of make it all work.
Look, Bob, I'm gonna have a meltdown, I think, on stage at this point.
Okay.
I think I'm just gonna full on rage. Because I don't actually think we have learned a whole hell of a lot that, what we should have. There should have been a 5-alarm fire in DC the minute that FTX happened. In fact, when Celsius happened back in May, that should have made clear that there were massive gaps in the regulatory system that left millions exposed, assets just kind of in limbo, management in place, able to kind of extract value when they should not be able to do so normally. And that should have led immediately to rule changes or some measures to protect those who were the most vulnerable. We have done this before. When Enron and WorldCom failed, we had Sarbanes-Oxley, right? We had the savings and loans crisis, we had the RTC, and we had measures immediately in place. We obviously, David mentioned the financial crisis in 2007. We had Dodd-Frank and all sorts of other stuff. This has happened, and nothing has happened in the regulatory sphere. Absolutely nothing. So, what we have seen is a whole bunch of effort, but ultimately no result. There are bills in Congress making their way through Congress. There's a lot of chat. But the main way in which we are doing regulation is through litigation and regulatory action through enforcement, rather than having measures that could do some very basic things, Bob, very basic things. One, just having rules in place to make crypto assets bankruptcy remote. These are bearer assets. We're dealing with passwords that denote ownership. Even when they are custodied with professional custodians, there is still a potential risk because they're holding the passwords, right? So just having basic rules in place to make these assets for themselves, crypto assets, bankruptcy remote in a way that works. CMF Global as to, what happens when things don't work and the compensatory mechanisms that kick in. Potential insurance arrangements. We see SIPC, for example, in the case of securities industry. Rules with respect to exchanges and, having some regime for exchanges to be regulated properly. Disclosure. We're not reinventing the wheel here, Bob, for the co-pilots. We're doing some very basic regulatory tailoring to make this industry safer, to start learning. Unfortunately, none of those things have happened. At the same time, of course, the crypto market is roaring back. There's a very great part to it, and I'm sure we'll talk about the FTX recoveries in a minute. But in addition, obviously, there's a lot on the sidelines, which is potentially re-upping some of the abuses that happen coming into crypto winter. So we do not have the guardrails in place still. Those guardrails are pretty minimal fixes that we have done many, many times before. But the potential risks are roaring back. I do not think that we've learned anything.
I want to fight with you.
Go for it.
Okay. Who are you sitting in Nashville saying to this huge industry, we need to protect you. You don't want your FDIC insurance, but we're going to give it to you anyway. You don't want regulation. A lot of it's moved away, offshore, did everything they can. And they say that you got to have it anyway, right? So is it fair? Let's face it, when there's collapse, everyone's like, well, we didn't like you lawyers, and we don't like you regulators, and we don't need your stinking FDIC insurance, but you bankruptcy lawyers, you better fix it for us because we are in need. We're like feeling destitute right now. And bankruptcy likes to say, you kind of assume the risks that you assume. Maybe it's a little paternalistic, to use a sexist term, to say that we need to give things that people don't really seem to want.
I'm going to get professorial because I got tenure, Okay. Let me just introduce the concept of externalities, Bob, which is that, creating risks that single institutions cannot bear by themselves, right? And those externalities are what merit, traditionally, right, regulations, which is that people are creating costs, creating risk for others that others cannot bear themselves, and they're, creating these larger spillover effects. As all of the co-panelists have highlighted so far, that is happening on a, industry-wide scale, where institutions are, creating short-term credit relationships that can lead to runs. as Ken highlighted, that we're dealing with management issues, as Ken highlighted, that can have spillover effects. Mo's talking about these things. So, the fact of having externalities is what traditionally requires some intervention. We are not saying have huge amounts of, crazy regulation, but minimal fixes that are shown to work historically. Mo mentioned the playbook, that are historically shown to work. Disclosure standards, custody remoteness, bankruptcy remoteness, basic consumer protection fixes. These customers cannot help themselves, and when they don't, they're on Reddit and onto you, Bob. So I think we need that.
Let's go to Mo. I know Mo wants to say something, but I'm going to throw it to you in a second. But let's build off of that for a second, right? Because if you have your account with a bank, if you have your account with a trading platform, a Wall Street shop, okay, and the thing fails, you usually get it back. Right. Sometimes it's insurance, but a lot of times it's just the systems have been set up so that they can't take your thing away from you, whether it be stocks, bonds, cash, whatever, okay, and use it for their own devices. But in these industries, which eschewed regulation and those types of apparatuses, the companies had access. And you talked before about when they have control, I'm going to use a word called opportunism, which is a little overly legalistic, but I think you know what I mean.
Bad guys.
Yeah. And now, whether they're bad guys in the Sam Bankman-Fried way or just regular C-suite people who are scared and frustrated, don't know what to do, you get that speed dial, Mo, and say, we're sitting on, we'll use BlockFi, $250 million worth of crypto today. What do we do with it? And what sort of bad stuff tends to happen then?
So look, I was going to jump in to defend my new friend, Yesha, because you were attacking her. I am 100% aligned that there needs to be some regulation. What was really interesting to me as a sort of fairly, novice to the crypto industry, only looking at it from a restructuring industry point of view, was that there was no protection for these for the customers. They had trusted bad people, and a little bit of this is lost in it because I was in a lot of these. We sort of looked at Voyager for the first time when it filed, weren't involved in that. And what happened? Voyager came in. What was interesting to me was that the crypto industry and all the sort of fans and followers of crypto and investors, customers of crypto, had assumed they didn't need regulation, which I certainly think has been proven that they do now to some extent. And at some level, my perception was Sam, in August and September of 22, was that Sam Bankman-Fried was the J.P. Morgan savior of the crypto industry. And he basically was going to come in and buy Voyager. He was in the process of buying Voyager and effectively do the rescue. And here's what's really interesting. 3 weeks after I got appointed as the creditors committee advisor for Celsius, we were immediately starting a sale process to see what was happening. I had lunch with his counsel, who said to me, you all do whatever you do in terms of looking at buyers and running the process. Sam's going to be he's the master of the universe. He's the only one who understands this. He will be the ultimate bidder, but sure, run around for 3 months and go do that. And that was, to me, like one of the sort of important things that's lost in here, that the crypto industry was sort of out on its own, expecting somebody to come save it. The regulators obviously did nothing to help because that didn't get approved, Binance didn't get approved. So there's a big issue there, whether the regulators wanted this company, this industry to survive. So that's sort of one theme that happened there. The second that I'll just highlight very quickly is that from one case to the next, there were, when you have train wrecks, happening in a serial order, you learn small lessons from one and apply it to the other without keeping the big picture in mind. So an example of that, Celsius When Celsius filed, they had crypto, but they didn't have cash, which was needed to fund the bankruptcy. So they immediately started negotiations with DIP lenders, debtor in possession financing lenders. And we, as a creditors committee advisors, looked at it and said, this makes no sense. You're going to spend, basically lenders were coming in and said, I'll charge you 100% a year because this is risky to lend against that. And we said, why don't you go sell some crypto to fund yourself, even at the price it is. So that's what they ended up doing. Fast forward 2 months later, BlockFi happens. And some idiot decided to go and sell 250 million of crypto at the low when 25 or 30 million could have been done. Could have sufficed.
Can we, for a teaching moment, just pause on this a minute? BlockFi is a bank, a quasi-bank. People deposited their crypto with the bank in what's akin to a savings account, okay? You transfer title to your crypto to the bank. That's why you have FDIC insurance. When you go to your savings and loan and thrift, that's what's happening. You're making a loan to the bank callable on demand, okay? And if the bank fails, well, thank God we have the FDIC helping you, right? 250 million domestic crypto was sent to BlockFi, and they sold all of it. Just after the CoinDesk article comes out, FTX implodes and is in bankruptcy 9 days later, and they're extraditing Sam Bankman-Fried to America. Could it get any worse in terms of timing to sell it? And what do you need $250 million for? And why dollars? Nobody wants the dollars, because that hits them with taxes if they can't get their crypto back. I've been doing this a long time, and I've said this many, many times. I think you agree with me. This may have been one of the worst decisions I've ever seen in any bankruptcy cases ever. I don't know. Do you agree with that?
Well, look, I would say, and I've been sort of chief restructuring officer of many, many companies, and I think you can debate whether it was I thought it was a terrible decision. So for the record, I agree with you. But perhaps not for the reasons that I had any particular insight into that was low and it'll go higher.
Right, it could have conceivably gone lower.
It could easily have gone lower. But here's the reason why I fundamentally disagree with it. I think they sold it within 3 weeks of a creditors committee getting appointed. The creditors committee had 9 people who were significant creditors and fiduciaries for the entire creditors and customer body. And to do that when it was unnecessary without consulting them is an abject failure in judgment.
No, it was intentional, I would say, because they wanted to do it before those stinking creditors can get in there and say, don't do that. That would be a bad idea. They wanted to insulate themselves. And what better way to insulate yourself from legal problems than have $250 million? Because boy, can you hire a lot of lawyers and bankers and other attributes of process. And Yesha, if I can channel you, they never should have had that opportunity to begin with. If regulation and process was in place, they never would have had the ability to take it from people, make that decision, build those moats. And in the end, that's your point, right?
Yep, exactly.
David, I'm hoping that you're going to solve this problem right now, right? Because if we learned one thing from these bankruptcy cases, it's that an awful lot gets disclosed. Alex Mashinsky was in charge for 2 months. Then he wasn't anymore. And then a few months thereafter comes a 685-page indictment that says, let me tell you a little about your good friend, Alex Mashinsky. 7 months later, he's hauled off in chains, okay? John Ray gets appointed in FTX in part because he was the Enron guy. If anyone ever was going to tell the world what actually was happening there, it was going to be John Ray. And we've seen this in case after case. That in Yesha, in my article, we talk about this grand public inquest that's been happening through all these bankruptcy cases. Is this not going to change behavior in the C-suite? If you're about to run one of these companies in the ground and you have the opportunity to go take that 250 and build your moat around you, you're not going to sit there and say, I don't want to do that. I don't want to go to jail. Are we now saved from the Alex Mashinskys of the world, and we never need to worry about them again? We don't need that stinking regulation anymore.
No, we're not. But in fairness, some of this is to blame with the bankruptcy system itself. And if you really think about it, at its core, the bankruptcy system is really managing, it's really helping the owners of companies, the debtors, restructure. They have the power at the beginning of the bankruptcy hearings. The first day filings, they have control over the assets. And what really happened in crypto that was specifically painful was you had failed business owners, these businesses failed, and now they got to make a choice on how they wanted to handle those assets. But they knew that their customers wanted their crypto. They did not want fiat. If they wanted fiat, they would have had fiat. They wouldn't have used those platforms in the first place. So they had to sit and watch while these, the owners of the companies made decisions that really candidly did not benefit the creditors, but candidly benefited the owners. And what are some of those examples? What was the first thing some of these owners were most concerned about? Who's going to get me a release at the end of this bankruptcy? Who's going to get me a release? Who is going to enable me to have a soft landing? And I think we all have to be very pragmatic about it. At some point, the creditors needed to come first, and in these bankruptcies, they didn't. Voyager, my old company, had a really useful product, had a nice, client base. There should have been an auction 1 or 2 weeks. You either get sold or you don't. In Voyager's case, FTX ended up being the buyer, but there was no backup bidder. I'm not a bankruptcy practitioner by day, but Bob, I think it's very unusual that there's not a backup bidder in a bankruptcy case. So every month you're churning 10, 15, $20 million of creditor money, running a company that is destined to be liquidated, and this is just not in the creditor's interests. And then one other thing I want to highlight, there's this fallacy that's gone around that maybe in FTX all the creditors are going to be made whole. I want to be clear for everyone in here that all the creditors will not be made whole. Being made whole is receiving the amount of crypto you had on the day FTX filed. It is not the dollarized amount of your crypto the day FTX filed. I challenge anyone in this room who really knows about crypto to push back on that thought process.
Wait, stress that point. This is really important. The FTX files in November of 2022. You're telling me that if I deposited $100 as of that date at the market low, that's my market assessment of what my balance is, but over the intervening extended period of time, that $100 is now worth $1,000, and I get paid in full, Pollyanna-ish. What do I get? The $100 or the $1,000?
You get $100 worth of fiat.
And I get taxes.
And you get taxes. And
super.
And I think the last thing is, I think people forgot, or maybe they didn't forget, but they just decided to turn the other cheek. But that people put crypto in these platforms because they believed in crypto and they wanted their crypto back. This concept of dollarization, which I think makes sense in the traditional bankruptcy context, and I'm not saying we rip up the script for crypto. It is just a fallacy. If you go to any creditor, crypto creditor, and say, hey, you got your $100 back, don't you feel good? I think they'd give you the answers you've seen in your Reddit flows.
Now this is a topic area that we learned a bunch. Not a lot of it's good, okay? And then we're gonna seek in a minute to what you all can learn from all this in your future business in a minute. But before we do, Ken, okay? Hardest question of all, I always reserve it for you. What did you learn and what will you do next time? When Kraken fails, what are you gonna do?
So look, I think as you probably understood from what everybody's saying, the biggest fixes require Congress. You've got to be able to avoid a Chapter 11 process, to avoid the management, as David said, running the process solely to benefit themselves. And you've also got to fix, in financial bankruptcies, when Lehman collapsed, if you had a share of Microsoft stock, you were supposed to get the Microsoft stock back. a similar fix needs to happen for a crypto company. It makes sense that the bankruptcy court doesn't want to deal in euros or yen, but everybody deposited Bitcoin, they wanted Bitcoin back. But what can we do if Congress doesn't act? Because that seems unlikely. Look, the only thing to do is speed, speed, speed. Yeah, the sale processes took months and they were all a failure. Even if they'd succeeded, they wouldn't have made enough money to pay back all of the fees that you spent over those months. And the price rise, the longer you stay in bankruptcy, the more the problem comes about. If all these bankruptcies had exited in 3 months, prices would have been close enough that it wouldn't have caused as much of a problem. And so if Congress doesn't act, which really the only thing that we have to do is next time everybody has to be pushing for speed, speed, speed. And unfortunately, given if debtor management is in control, there's going to have to be hard questions on, do we let these people go even if they did something really bad, rather than let them hold the bankruptcy up for 3 or 6 or 9 more months?
Well, let's see back to Yesha on that. And we're going to move now into this whole idea about how do you guys think about deal making going forward on this? And we're going to go back in a regulatory way in a minute, but I'm going to bridge, okay, to what Ken just said. Lehman Brothers had a bankruptcy, and it went for a long period of time. But the heart of Lehman's bankruptcy was something that happened before the bankruptcy, which was a sale transaction of the parts of the bank which happened in a weekend. Washington Mutual had a bankruptcy. It lasted for a very long time. But the heart of the Washington Mutual bankruptcy was the marriage made by Tim Geithner and Paulson with Jamie Dimon the weekend before, where the bank was moved over to J.P. Morgan. We can keep going down the line of banks and Wall Street powerhouses that collapsed and failed, but just before they did, in that fateful weekend before, the heart of the business was saved and moved to a stronger platform. Not so much in this industry, okay? Ken wants to talk about speed, 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 which is right. I mean, we learned a bunch from these cases, but one thing that we learned is that they're not fine wine, they don't age well, okay? But one other thing that we learned too is that there's a missing apparatus here. The capacity, the need, and somewhat government impulse to force that matchmaking as calamity is happening. Do you think that changes?
I don't see that changing in the near term. And this is coming to the earlier point that's been made, is that we fully have not engaged with the deeper financial characteristics of crypto in terms of its increasing financialization at present. I think the inability of the regulatory apparatus to understand the technology, to understand the linkages between that technology and financial transaction deal making has meant that we are underpricing the risk of failure in a way that would merit having this larger apparatus come into being. Frankly, coming back to the earlier rage issues that I've had, this apparatus is sorely needed. We are dealing with extreme run risk. We are dealing with very quick depreciation of assets, as you mentioned. We are dealing with, potential catastrophic corporate governance decisions. This is exactly where some kind of resolution regime, having some kind of FDIC kind of coming in over the weekend, having some level of emergency financing that can be provided in a pinch to enable deals to go forward, to have some form of collateralization of assets that can be used to release that capital. Having those mechanisms in place can at least put, the industry on a surer footing, and much more, put customers in a safer position with respect to their assets and the money that they're putting into the system. I think there's still this view, at least my kind of anecdotal experience, that the crypto industry doesn't deserve it. That they don't deserve the fact it's a risky industry, people take the risk. But ultimately, we're talking about real people here. real people who put their savings into crypto and who, merit feeling safe in that system. One thing that I will, just close out with is that we forget who these real people are. Which is to say that crypto has been embraced by communities that have been excluded historically from the financial sector. When you look at a Harris poll in like 2022 or 2021, I can't remember, it showed that, for example, that 23% of Black Americans own crypto, 19% of Latinx Americans, 25% plus of LGBTQI plus Americans, right, own crypto. These are, people that have felt disenfranchised from the system, who have now been burnt because their crypto has exploded, in these different bankruptcies. These are the folks that we need to protect. We've done it historically. These kind of moralistic ideas of who deserves it and who doesn't needs to just go in the bin. And regulators need to do what we ask them to do, which is protect the average person, as well as the system as a whole, which is increasingly financializing. And, we don't need to even talk about ETFs to get there.
But my interpretation of everything you just said, which I totally agree with, is for the commercial folks, it's just going to cost more now.
Yep.
Everything is going to cost more because now we know the cost of failure.
And do not underprice litigation risk. Overprice it.
Mo, can you talk a minute about if you were dealing with Macy's? I'll just pick that one out of the hat. And by the way, I mentioned Kraken before, and I shouldn't have done that. That's not I have no idea. And I don't know about Macy's either, for that matter. But you're dealing with a normal company. You're dealing with a retailer, a airline, a steel company, even an auto company if you choose, okay? And not that crypto is not a regular company, but in categories that are old economy or less new economy than what we're dealing with here, there is time. You get that hot phone, the billionaire calls you and say, Mo, get over here, we need your help badly. How does time and time management and the way in which deals are constructed to create or take away time mean money?
So look, I think for this industry, I think it is time can certainly be helpful, and some of the lessons learned. So, for instance, the idea that you spend 3 or 4 months incurring ridiculous amounts of fees and cost chasing a sale, which is, any sort of seasoned person could look at this and say, particularly post the FTX collapse, I think pre-FTX, there seemed to be a market for these companies. But all of that could be looked at. The fundamental question goes back to what Yesha was saying, which is you need some basic framework for regulation where assets, customer assets, can be separated from ongoing businesses.
I want to get more pinpointed with you. Okay, now we're going to, in the 3 minutes we have left. I got a steel mill. The banks are coming. The IRS is coming, and I got a union that doesn't want to work with me anymore. Okay? My maturity date, or my coupon date, or my union strike date is 30 days, 60 days, and we're talking.
Mm-hmm.
Versus, I got Luna collapse. 3 days later, I got Voyager calling on 3 Arrows' $675 million loan. 3 Arrows goes into the Caymans, whether it likes it or it doesn't like it. Voyager has to announce this, and then comes the run on the bank. There's no time. There's no capacity to talk. How does that change behavior patterns?
Well, look, it definitely creates challenges, but I think in those instances, if you can identify fulcrum stakeholders or prospective investors, you can proactively structure a solution. I mean, Lehman got sold in a weekend. It was a gigantic institution. If you look at the big financial crisis, Silicon Valley Bank was a massive bank. It got dealt with in a weekend. Why? Because there were people willing to take those assets. And there was a system. I think that can be done, but it requires cooperation from regulators, investors and management and a structure and a system to get that done.
David, are we going to have better CEOs now?
Well, I think we're going to have better CEOs, but I want to bring one other thing to bear. In these bankruptcies that happened quickly, there were very few professionals who really understood this business. And I think the bankruptcies were hurt by the financial professionals not really understanding the business, not understanding how to value this business. And I think they learned over time. But I think the professionals in these cases, really needed to learn over time. And because it was so new to them, the first few bankruptcies suffered from that.
Dave, Ken, I'm going to give you a final word. So now we learned you're not getting regulation, so everything's going to be much more expensive, especially for communities that have not been as much participants in the financial system. CEOs may not be better, and you're not going to get more time unless these guys start changing their deal making. Okay? What, as a lawyer who actually is a little bit of a veteran of this scenario, are you going to tell people to do?
So look, you're going to have to protect yourself, unfortunately. The contracts that you sign with these companies are going to be very important. There's no way if you're lending money to them, you're going to be anything other than a creditor. But what really got people burned was they took out a loan from these companies, posted collateral, and they thought that collateral would be safe. And it wasn't, because there was details in the fine print that said the company could resell their collateral. If you're ever posting collateral to another company, you need to look at the contract and make sure that the collateral never becomes theirs. Because the people who got burned the most, who didn't realize they were at all at risk, were the people who'd posted collateral to these companies, taken out a loan, and when they hit bankruptcy, realized that collateral isn't mine anymore under this contract.
So the upshot of this very lengthy conversation we had is just write better contracts. It seems to be. I think we're out of time. Thank you all for listening to us. I hope you learned a little bit.